Okay, I think we should start moving along now. Obviously, anyone who joins will be able to pick up. Thank you for those who've attended for today's Employment Law Club webinar. My name's Robert Maddox. I'm an associate in the Employment Law team, and today we're joined by Katie Wheatley, who is a partner and head of our crime, fraud and regulatory team, and we're very pleased and lucky to have Katie along today to help discuss some topics that are going to touch on regulatory and crime-related matters for employers and companies. But before we start, some of the obligatory webinar housekeeping points. Firstly, this is being recorded, so if you are unable to attend for the whole thing and have to drop out, we will be circulating a recording, and you'll be able to watch anything else there, and also be able to circulate to any colleagues or anyone who's not able to attend. Questions, we will try and have some time to take some questions if anyone has any at the end, and they can be submitted through the Q&A function, which is the bottom of the screen. Hopefully everyone's familiar with that now, having attended a fair few of these webinars over the past few months. We will be circulating a feedback sheet. Again, they really are helpful to us. We'd be really grateful if you could complete, and that will be circulated in the same form as the email as the recording of the webinar. And that will also provide my and Katie's email addresses if you have any follow-up queries. The contents of this webinar is not strictly legal advice. It's to discuss and touch on some important points that we think will be relevant to you. If anything that's discussed is particularly relevant to you or your business, please do feel free just to drop us an email, and then we'll be able to take it from there and see how we can help. So that's the housekeeping stuff out of the way. And moving on then to the sort of nub of our talk. And as I said, the aim of these seminars generally is just to touch on some potential areas. They're obviously short. They're meant to be a fairly informal discussion. We don't intend to circulate notes or slides, but there is the recording, and obviously follow up with us. And I think there may be some blogs of some of the content that's going to follow up on this webinar. We're very lucky to have Katie Wheatley, and that's going to lead some of the discussion that we're going to have today about points to know and just to be wary of for companies of employers along the regulatory and crime sort of area. The purpose of, and that's the purpose of this particular webinar, it's to address some of those areas that might catch out completely fair-minded and compliant employers that can then lead to employment law, regulatory, or potentially even criminal issues. It's not meant to be a scary session or scaremongering. It's more just to highlight those areas and make sure that we've considered them carefully and have up-to-date processes and safeguardings in place. Now, for my part of the talk, I'm going to touch on furlough, and I was in two minds about whether to include that on the flyer or address it, because I'm aware that we've probably all been to a fair few furlough talks over the past few months, and we're now familiar with the scheme and probably all familiar with its operation, and that's fine. But I also then thought to myself that that is a good intro and a good opportunity to discuss some of the other issues in this talk, because that comfort and familiarity with what is essentially an HMRC Treasury-led public money scheme can lead to mistakes, and it can mean that we lose sight of the importance of making sure that we comply properly with the regulations. Because HMRC do have investigatory powers, they do have penalty powers, and they do also have the ability to prosecute in certain circumstances. And we all obviously want to avoid that as much as in a reasonable and compliant way. So apologies if people did join this thinking that I was going to be recapping the scheme and what the ins and outs and the technical nature of it. If you have any queries about that, please do just drop me an email. I'll look at the regs. I think we're on regulation 110 or something like that by now, the 110th iteration of it. But I'll take a look through and I'll answer your queries. But this is more about the importance of employers, ensuring employees and managers are continuing to comply with the ongoing fundamental requirements of the scheme. And those are, ensuring employees do not work on furlough days, ensuring that the right sums are claimed, ensuring that people are working the hours that they're meant to be working in accordance with the understanding of your payroll and the understanding of your agreements with people who are on furlough. And that's become particularly important, not just because of the familiarity of the scheme, but when we entered flexible furlough, there was even more scope for confusion, accidental errant claims, and employers and payroll need to be aware and reminded of the importance of ensuring only correct claims are made. So that being said, these are my sort of top tips, if you like, for June 2021 furlough refreshers. And it probably won't surprise many of you to know that number one is maintaining records. It's something that in HR and in compliance will be more than aware of. You need to maintain the records of the agreements that you have with each staff. Maintain a record that the staff on the particular agreement are still working, despite flexible furlough, still working the hours that they were originally agreed to be working. If they're not, you will need to have an updated furlough agreement with that person or a furlough letter underlying the new flexible hours they're working. And this may be particularly important now, certainly for businesses in hospitality that might have an acute demand for furloughed staff when the weather is nice, and they're not so much when the weather is raining, and they may want to try and furlough people at that time. You just need to be on top of those records and furlough agreements that you have with staff. And the reason for that is employers that have a recorded approach to furlough will be better placed if HMRC query payments that have been made or ask for more information. You'll just be able to respond to that in a much more measured and detailed way, which is always going to help. Or alternatively, it will help you uncover where you may not have people working in accordance with the agreements you thought, and it might help you identify any incorrect claims to HMRC, and you do have a 30-day grace period to correct any errant claims with HMRC without suffering a penalty. So it is important. I will touch on penalties a little bit later on in this talk. Tip 2, reminders. Again, it's another HR and employment law staple, but it's a good time to remind staff and their managers of the requirements of furlough not to work. Because if someone's been on furlough a long time, this may not be the case for the vast majority of the people and of your employees or any employees. But it may just have that little bit of creep into, well, I can just send that email or I can just do this thing while I'm on furlough. And they're only small things. They're unlikely to, we don't know to what extent HMRC are going to explore these things. So it's just better to ensure that as a company, you're able to say, well, here are our prompts, here are our reminders throughout the process, rather than HMRC asking you, how did you update staff? And then you're referring to a letter that you sent to them in 2020. Again, there's an element of that we do need to be careful about as HR and employment practitioners, because you'll know your staff and your workforce, and you may know that the presentation of a refresher of information is always important. So you won't want it to make it look like there's fire behind the smoke, if that analogy works, if that's similar, if that idiom works in any way in this context. But you might want to avoid rumours that refreshers are a result of breaches. So present it in a neutral way and say, under our requirements of the scheme, we're just reminding staff that it's important not to work on furlough days. and it's important to stick to the hours that we have agreed with you. And then that will help you in many cases, if there's any retrospective inquiry by HMRC into the use of furlough. And my next and final tip is more of an encapsulating one of just be aware of the importance that the claims you make are correct. So as I've said, HMRC can check claims. We don't know to what extent they will. Presumably they will start at the top of looking at the very fraudulent claims and then maybe explore others at a sort of lower severe threshold. But it's just always better in these kinds of situations to make sure that you preempt and prevent rather than attempt to remedy later. And so make sure that the claims you make are correct. HMRC's first step can be to withhold payments and then seek an investigation. And then they can pursue employers who break the CJRS rules either intentionally or completely accidentally. Obviously, there's a scale to what HMRC may do in if it's intentional or if it's accidental, but they can still explore and investigate accidental issues. And with that in mind, you know, the process that HMRC are likely to go, or the approach that they're likely to take, is to focus on employers who have made employees work despite claiming furlough. Again, intentionally, probably more prevalently, and then accidentally, or then look for employers that do not pass on the full furlough payment to staff, or traded profitably and didn't need the payments. So they're the sort of broad areas that you might need to be wary of. Generally, HMRC's first step would be to investigate and communicate with the employer and say, we think there may be a mistake. Can you provide confirmation and documentation to prove that these claims are appropriately made? And that's where the record keeping points that I was making earlier become really helpful, because HMRC can then impose a penalty, and that penalty can be up to 100% tax rate on the payments received. If your company has received a lot of furlough, that's a lot of penalty, which is particularly important because HMRC could then prosecute employers who fail to pay tax demands. Now, as I mentioned earlier, an employer has 30 days to self-declare a mistake, and that's where the record keeping and the importance of just being on top of the payments that you make comes in handy. You'll have noted that in that process of HMRC, there's a few steps in that process, and hopefully the points that I've flagged will help reduce the prospect of any HMRC investigation or put you in a good position to respond to anything and show that you're all compliant and recorded up. And that sort of leads me on to Katie a little bit, the next step of the HMRC process. She's going to move on from furlough specifically to other areas that an employer or company will need to be mindful of at the more serious end of the scale. And if I could move over to you then, Katie, to share with us your thoughts.
Hello, yes, everyone, good lunchtime, I should say to everyone, and it's really lovely to see you giving up some time to meet with us, and I'm sorry we can't see you, but I hope you're going to find the talk interesting, and as Rob says, if there is anything that you're not sure about, then please do drop us a line afterwards. Just give me a minute, because I have got some notes that I'm going to refer to, which I just want to start. So, So the areas that I'm going to cover are how the actions of employees at their work can lead to either regulatory or criminal implications for organisations, and also the types of investigations that can arise in those circumstances. I'm really, as I say, talking really about criminal and regulatory matters. That's because that's my field of specialism, but you'll be aware that actions of employees can obviously trigger other legal risks, which I wouldn't be covering in this talk. And also, of course, I'm just covering the law in the UK. And if organisations trade or operate abroad, they need to be aware of potential liability in those jurisdictions where lawyers can be found to give the relevant legal advice. So in terms of criminal law, we often think of, well, perhaps more historically thinking of the actions of individuals splattered over the tabloids and things like that, but more commonly now, we are seeing issues of corporate criminal liability arising, and you'll be aware of news stories about that, I'm sure. Not every action of an individual employee by any means will attract any form of criminal or particularly criminal or regulatory liability for the organisations that they're working in. But where there is a potential scope for liability, it is quite broad and can cover liability not only for the employees, but also for freelancers and subcontractors. And the types of organisations that might typically investigate companies would be, well, first of all, of course, the police, but also people like the Serious Fraud Office, HMRC, and regulators like the Financial Conduct Authority or the Health and Safety Executive, and also on occasions local authorities. So often the sort of corporate investigations might focus on actions that are financial in nature. Just sort of moving on or touching on Rob's example, for example, an individual manager claiming furlough funds for employees who are continuing to work in the organisation beyond the hours agreed under the furlough agreement. But of course, it can extend to any form of crime committed in a business context. So you've got health and safety, fire safety, various regulations sort of overseen by local authorities, and also injury and even manslaughter. Mostly criminal liability attracts to actions rather than inactions. And so, but in the world of corporate liability, it is more common to have failures as a type of criminal liability. So, for example, in some sectors, failing to report suspicions of money laundering, or for organisations, failing to prevent bribery or breach of health and safety law. There are all sorts of failing to act type offences. The other thing to think about is that where an employee commits an act which may be criminal in nature, it's not really often that when the company is an unwitting conduit of that activity that the liability will be attracted. But more commonly, where the action actually is perceived as creating a benefit of some kind for the employer, either business generation or operating in a way that cuts costs in order to complete work, and which can cause obviously risk of harm in different ways. And those cases can be quite complex, both in terms of investigation and also attributing liability both to individuals, but also whether it's appropriate to attribute it to the company as well. And they become more complex when there are sort of civil and employment proceedings running parallel. The types of action that an employee commits will, in most ways, attach to the company, either because there's deemed to be some form of what's known as vicarious liability, which you might have heard about a bit more in a civil context. So fairly basic offences like driving, which don't require proof of a specific kind of criminal state of mind. But for more serious offences, which do require a sort of state of mind, so for example, fraud would require dishonesty, So for offences like that, then the company can also be convicted alongside individuals if it is deemed that the offence was committed by the directing mind and will of the company. And the directing mind and will of the company is usually senior level employees, such as directors, but in some cases can extend beyond that. It's also worth bearing in mind that statutes can often provide for, in cases of corporate offending, for a company director or officer to be liable alongside if it's found that the offence has been committed with the consent, connivance or neglect of that particular individual. And you can find examples of this in Section 14 of the Bribery Act or Section 37 of the Health and Safety at Work Act. When it comes to things like corporate manslaughter, only companies can be convicted of that, but employees whose actions might have caused death can be investigated for other types of manslaughter, like gross negligence manslaughter or health and safety offences. So I think I've briefly touched on the fact that criminal offence is usually defined by two elements. First of all, a conduct element, or a lack of conduct, and secondly, a state of mind. And a person can only be convicted and punished if all of those elements can be proved. And in the case of corporates, they have to prove that for most of the serious offences that it's directing mind and will, or in those types of more regulatory offences that there has been a relevant failure without good reason. And the standard is usually beyond reasonable doubt, the standard of proof. But although that sounds like quite a high standard, obviously, if the evidence is there, convictions can be achieved by regulators. So the question really is for all organisations that from time to time misconduct will come up, and I'm sure as HR professionals, you more than me will know that. And the question is how to sift out the cases which we would deal with by a normal internal process, through a disciplinary process, and what are potentially more serious and might present a very serious threat to the organisation's ability to conduct business or its reputation. So, for example, if the activity might mean regulatory sanctions or not being able to undertake certain sorts of work, or obviously prosecution would be very serious indeed. So so if we take the most straightforward type of investigation, which is the misconduct investigation that Rob and you will know much more than me about, the only thing I wanted to mention there is that any material that is generated by those investigations may be sought by any external investigator like the police, alongside the sort of basic documentary evidence of the wrongdoing itself. And so that would be sort of brought up into the investigation and could be used in evidence in relation to the employee in those sort of simple cases. If in the case of a broader kind of regulatory internal investigation, then it is necessary to look a bit further, and quite often companies might think about instructing lawyers at that stage once they realise that or have done a kind of preliminary assessment. And the reason for that is so that all the relevant evidence can be preserved, and then the correct steps taken that allows for an objective approach, because it can be quite hard for an organisation to investigate itself. You think about, just having somebody who doesn't know any of the people involved, who's taking a fresh eye at procedures, and the evidence can be very helpful. And also it means that then the organisation can receive and consider advice about whether and to whom the matter should be reported externally. Sometimes there are obligations to self-report, but even if there aren't, it may be that there would be good reason to, if it's likely that the matter is going to come to the knowledge of investigators and likely to be proved, because self-reporting is one step in the stepping stones for sort of showing cooperation and achieving lower penalties. But on the other hand, obviously one doesn't want to own up to things unless there is an important a regulatory obligation or good reason to do that. And obviously that is something that companies also commonly seek legal advice about. For these, I've called these internal regulatory investigations because they're conducted by the company either by itself or with the input of external lawyers. But it's also the case that to some extent legal privilege might cover, in depending on the facts and the circumstances, the material that's generated by those investigations. But there's been a lot of litigation recently about legal privilege and the extent to which it applies to these types of investigation. And so, legal advice on that would be fact specific, but it is perceived as something that can apply to material that's generated by lawyers, helping companies conduct their internal regulatory investigations. The other thing to think about is that is a sequencing, because the internal regulatory investigation would be distinct from any disciplinary proceedings and investigations that were going for individuals. And so whilst you might consider it necessary to look quite swiftly at an individual, depending on the type of risk you think that they pose to an organisation, it may be quite difficult to do that until all the full facts are out. I mean, you could imagine a situation where an individual says they have committed an act, but then says that a senior manager insisted that they do it, and you can see that it would be quite difficult to come to a conclusion about what to do with them until that had all been fully investigated. And so again, those decisions, those sequencing decisions, would have to be something to be thought about at the outset before launching one or the other and deciding whether to do one first and then the other, or to run them alongside each other. And the other thing to think about is that when you've got somebody who's still an employee and they're asked to assist the company to think about whether that some harm may or breach may have been committed, they would normally, as I understand it, have some form of obligation as an employee to cooperate. And you might then get more information from them than if they are feeling that they're, than if their employment has already been terminated. And obviously, then they wouldn't have that as any form of leverage at all. The other thing is that sometimes legal representation is offered to the employees if it's complex, and that can mean that disclosure is provided ahead of interview, which then in turn can assist the employee to give a clear account, which is much more helpful than throwing everything to them cold, and might actually speed up the sort of interview process in the investigation. It's also the case that these organisational internal investigations can run alongside each other, alongside investigations by the police, SFO, or regulators. And in those cases, it's obviously important that there's some coordination, because the company wouldn't want the investigators to think that they were sort of obstructing or trying to take sort of priority or precedence with some of the material that might be very useful and important to investigators. So there would normally be a dialogue and an agreement reached as to the extent to which the company is able to investigate itself, which is obviously important for the organisation. The other thing, really, just to sort of, I suppose this is really to wrap things up, is to say, I know Rob touched already on training and practices and procedures, and you will of course all know where the risks lie in your organisation, and be able to put those procedures in place to prevent and detect the types of activity that might be a bit of a red flag to you. But alongside that, and again, depending on level of risk, it might be worth the business looking at levels of insurance for the company, and also for key members of staff, such as directors and officers, so that if they are thrown into these a sort of criminal investigation, either one brought by the regulators or even internal one, that there is a sort of adequate level of cost cover for them. Otherwise, that would be something that would fall directly on the organisation, and could actually be quite expensive in itself. So that I think that was all I was. It was a bit of a sort of dance through, because I know this is a very short session, and I know you're all busy and squeezing this in the middle of the day. But I hope you found it helpful, and of course I'm very happy to take questions if there's anything that springs to mind now, or do feel free to contact me later if you prefer. Okay, I'll hand back to Rob now.
Thanks, Katie. Well, certainly, on behalf, as an employment lawyer, I found that incredibly interesting and really helpful, because it really puts into context a lot of the things that we do as employment or HR advisors in those kinds of acutely difficult situations, and gives us some further information of the other things that we need to be thinking about when faced with those complex scenarios. So thank you for that. We've run over a touch, and I can see no questions in the Q&A. I don't know if anyone wants to pop one in there now, and we may be able to address it. If not, then we've overrun a touch, and I apologise for that, and I'll be able to let you get on with your no doubt very busy days, or organising all of your furloughed employees and considering return to offices and things like that, which may well be a topic that we touch on in a future webinar. The feedback form I see has been popped into the chat there. Just before we sign off, in a future webinar, we have lined up, I think, Monica Sobieski, who is a partner in our information and data protection team, who is vastly experienced advising organizations on data protection issues and information related queries and issues, and that should be really interesting as a talk. And I know that Monica would be more than welcome to consider any requests for things that she wants to have covered in that talk. So if anything is particularly relevant to your organization, drop us an email on the information that's going to be provided, and we'll filter that through to Monica and see if she can touch on that in her talk. But say for that, just to thank you for coming on behalf of myself and also Katie, no doubt, and enjoy the rest of your day.